Hi, my name is Kaisa Krusko, and I am a family law attorney in Bedford, New Hampshire. This segment will focus on alimony in New Hampshire. In New Hampshire, alimony is purely statutory, meaning that the court's authority to issue an award of alimony comes from the laws passed by the legislature. There is no constitutional right to alimony. The law in New Hampshire on alimony is RSA 458-19. And if you review that section of the statute, it will give you a good idea of what the court will look at when issuing an award of alimony. The law says that the person to receive alimony must have the need for alimony. The court will look to the reasonable needs of the person to receive alimony, and the person who is paying alimony must have the ability to pay. The primary purpose of alimony in New Hampshire is rehabilitative, meaning that the court will order alimony in order to make sure that both parties have the ability to be self-supporting and meet their reasonable needs in the future. So the court will usually issue an order that will meet their needs for a certain length of time, after which time the parties are expected to be self-supporting. However, the court does have the authority to issue an alimony award for an indefinite or a lifetime amount of alimony where appropriate. If you review RSA 458-19, there are several factors that the law says the court should consider when issuing an order of alimony. One of those factors is the length of the marriage. It is much more likely that a long-term marriage will result in an alimony award. So a marriage of 10, 15, 20 years is much more likely to have an award of alimony than a marriage of 1 to 5 years, which would be considered a short-term marriage. The law says that the court must also consider the age of both the parties, given that in most circumstances alimony will be rehabilitative. The age of the parties can matter, where somebody who is older and closer to retirement age is not going to have the ability to retrain or get further education or move up the ladder in a job in order to be more self-supporting and meet their reasonable needs. Whereas a younger person is going to be able to get education and training in order to improve their employment status. The court will also look to the health of the parties, and this can be an important factor in issuing alimony. If a person to receive alimony has a disability or a health issue that will prevent them from working, that will be an important point for the court to consider. The court will also look to the occupation of each of the parties, and what is that occupation that each of the parties is in as far as their ability to support their income in the future. Somebody who works in an assistant type job where there are lower pay, lower benefits, might have a different outlook for the future than somebody who works in a corporate environment with a high paying job and bonuses and a lot of benefits. That the court was also going to look at the amount and the sources of the income of the parties. So also going beyond what they each receive from their employment, the court is going to look to see whether there is a child support award that would change the circumstances in each of the households. The court may look to whether there is other income, such as a trust income or investment income, which will also help support the person who needs alimony. The court will also review the property division made in the divorce. So if there is a large amount of property that is going to be divided, can that property support the reasonable needs without an award of alimony? For example, if the person who is paying alimony receives property and the person who is receiving alimony receives property, is the person who would receive alimony be required to draw down the assets that they would receive so that in the end they would have nothing left in the future when they get to retirement age to support themselves. The court is also going to look at the opportunity for each to, in the future, acquire capital, assets, and income. For a person who is in a job that doesn't have benefits, doesn't have stock options, doesn't have, if the person doesn't have extra money at the end of the month to set aside into a savings account, are they going to be able to plan for their retirement in the future, as opposed to the person who might be paying alimony, who has a 401k that is matched by the employer, who receives stock options and bonuses, and is going to be able to grow their wealth and have a good outlook for their future. The court can also review the fault of either party in the breakdown of the marriage. So the fault grounds that are listed under RSA 458-16A. And these can include the adultery of the parties, of either party, or the cruel and abusive treatment of either of the parties. The court can take that into consideration. The court is also going to take into consideration the tax consequences. The person who pays alimony is going to be able to deduct that amount from their tax income and decrease their overall tax liability, whereas the person who receives alimony is going to have to claim that alimony as income. The court may consider how much taxes the award of alimony would have, so that the person who receiving alimony can still meet their reasonable needs and pay for the tax consequences of the alimony award. There are several things to take into account when discussing alimony. First, that alimony is gender neutral. Either men or women can receive alimony. The court also has broad discretion when issuing an award of alimony. In New Hampshire, there is no formula for alimony, meaning that there is nothing that is going to make a set determination based on the income of the parties or other factors for either a monthly amount of alimony or how long the alimony will be paid. Alimony cannot be waived in a divorce stipulation, meaning that if you come to an agreement in your divorce and you do not have an agreement for alimony in that divorce stipulation, at any time within 5 years from the date of the divorce decree, or if alimony has been ordered for a definite period of time within 5 years from the date of the last payment, the recipient of the alimony can come back to court and ask for a modification of the divorce decree to ask for alimony to be paid in the future. When assessing the reasonable needs of the person receiving alimony, the court will also look to the lifestyle of the marriage. Was this a marriage where the parties traveled extensively, where they were able to go out to eat, where they were able to buy certain luxuries? Or was this a marriage where the parties did not travel, where they stayed home, where their focus was on financial planning or savings, saving their money, or whether they didn't even have the ability to have those extra luxuries in life? When coming to an agreement on alimony, it's important to look to the details of that agreement. Oftentimes, an agreement on alimony can include a provision that either the cohabitation or the marriage of the person receiving alimony will terminate the alimony. And you'll want to be sure that you have specific language defining what cohabitation means. Last important point to consider about alimony is it can be modifiable based on a substantial change in circumstances that would require the court to modify the amount of alimony. So for example, if somebody was laid off and they didn't have the ability to meet or pay the alimony anymore, that could be a reason to terminate the alimony. If you have any questions about alimony, please feel free to contact my office about further information. Thank you.